In the hearing, the learned Solicitor General appeared and pointed out the infirmities in the order, the errors in the order. The order turns on its head more than 75 years of criminal jurisprudence, which provides that any case, even a heinous murder, can be proceeded with on the basis of a private complaint. The impugned order, which we have challenged, basically says that the proceedings under PMLA cannot be initiated on the basis of a private complaint unless there is a registered FIR. What we pointed out was that in the private complaint, the cognizance is taken by a competent magistrate upheld by the Delhi High Court, upheld by the Supreme Court. Therefore, the existence of the scheduled offence was not in question. And the moment existence of scheduled offence of cheating and criminal conspiracy is not in question, the offence of laundering is clearly made out because judicial mind has been applied.
Sir, you've also said that it creates a split between the jurisdiction of the court and the jurisdiction of the police station. What were the exact grounds on which you've challenged?
What was argued was that the learned Solicitor General pointed out that an artificial distinction has been sought to be created between investigation done by a police and a private complaint filed before a magistrate, because a magistrate is also fully capable of, under the CRPC, of conducting inquiry under 202 of the CRPC, either with the aid of the police or somebody else. The magistrate, when a complaint is filed before it, examines the complainant, examines the witnesses, examines the entire complaint and then takes cognizance. Therefore, to presume and suggest that an FIR stands on a higher pedestal is completely incorrect by the impugned order. The impugned order holds that unless there is an FIR, PMLA proceedings cannot be triggered, ED can't proceed. So in effect, it gives a free pass or a hall pass to money launderers only because the procedure adopted in the scheduled offence is a complaint case. That can't be. There is no bar created in the statute. If the bar is not there, how can a court by an interpretation add a bar? That's the job of the legislature. And what is most interesting, the allegations on the merits have not been dealt with in the impugned order. In fact, the impugned order says we are not touching the merits of the allegation, but on this technicality we are declining cognizance. Those are the only things that I can say because matter is sub judice. I'm only reporting to you what has been argued. Thank you.
Sir, the matter is now listed in March. What do you expect in March?
Matter was thereafter mentioned and the date has been preponed to the 19th of February with the consent of parties.